Okay, let's see. Are we down to one or, okay, the appellant did not,
The appellant
Okay.
hasn't arrived.
okay, well, call the case and then we'll, please. I'm sorry.
Hwang versus Jerry Arita et al.
Okay, and the appellant is not here today, correct? All right, we will take his portion of argument on brief. We'll hear from the appellee, whatever the appellee has to say here today.
Good morning, Your Honors.
Good morning.
I'm Scott Vincent here for the only remaining defendant in this case, despite the fact that there are multiple defendants who are still named, Mr. Jerry Arita. I'm in an interesting situation because I figure the more I talk, the worse I can do, considering my adversary did not show up today. But very briefly, our position is very simple. This is a case that was pending for many, many years in Shelby County Circuit Court, and it's a car wreck case. That's what it really is. The plaintiff, Mr. Hwang, this is not the first time that this court has had an experience with Mr. Hwang. He was actually involved in a case that was decided in March of last year. It was Hwang versus Holt. It was basically the exact same case. Mr. Hwang had filed a lawsuit against a number of parties following a car accident. Whether or not he was injured.
Same transaction?
No, not as this. Completely different case.
Okay.
Mr. Hwang is what some might call a professional litigant. He's been involved in a lot of lawsuits of various sorts. The Holt case is interesting, though, because it's basically this case, just with different parties. And that case involved a number of discovery violations by Mr. Hwang. And ultimately, the judge in that case dismissed the case because of his multiple discovery violations under the court's inherent powers to sanction parties and under Rule 37. Mr. Hwang, in that case, and I'll get to this one in a minute, but I think the Holt case is instructive on this case. Mr. Hwang filed a brief in the Holt matter, and ultimately it was briefed and there was oral argument, I think, on that one. And this court ultimately found that Mr. Hwang's briefing was so deficient that the case was the appeal was dismissed on that basis alone for failure to comply with Rules 27 of the Rules of Appellate Procedure and Rule 6 of the Rules of the Court of Appeals. So the court never got to the merits of whether or not the judge was correct in dismissing the case. We'll fast forward a little bit, and we have this case. And it started in 2019, followed shortly after the car wreck. Based upon a number of filings, I believe that Mr. Hwang might have been represented for a minute, but he ultimately proceeded pro se and has done that throughout this case. There was a scheduling order that went down early on in the case, and further back up. Whenever Mr. Hwang filed his lawsuit, he sued a number of people. He sued my client for being involved in the car wreck. He sued St. Francis Hospital, which was one of the providers. Mr. Hwang went to the hospital that day. The City of Memphis Police Department and the Fire Department. And he sued all of these people, if you read the complaint, because basically he was aggrieved at how people treated him. I think perhaps someone with the police department might have referenced that he was Chinese rather than Korean, which is what he is. And Mr. Hwang took a lot of that great umbrage at all this, which led us down a multi-year path of litigation. Whenever St. Francis was served, that party removed the case and alleged a number of federal questions and said that they, as well as the city, should be let out. The district court agreed with that. Mr. Hwang appealed that to the Sixth Circuit. Sixth Circuit agreed with that, remanded the case back to Shelby County Circuit Court, which is where my client ended up as the target of Mr. Hwang's wrath for a number of years. At some point in litigation, which is set forth in the brief, and I won't spend too much time talking about dates, but there was a scheduling order that was entered which required, and this was in July 26 of 2022, set a trial date and required that all outstanding discovery be responded to by September 16th of 2022. Mr. Hwang did not do that, which led us to a number of motions to compel and orders compelling discovery that ultimately got us to November 1st of 2023. November 1st, 2023, Judge Felicia Corbin Johnson, who was the trial court judge at the time, after a number of threats to Mr. Hwang to act right, play right by the rules, respond properly to discovery, dismiss Mr. Hwang's case without prejudice, and basically even invited Mr. Hwang, and I'm not sure I agree with the propriety of this, but we'll talk about that in a second if you all want, to basically file some discovery post-dismissal, and if it complied with the rules of civil procedure, perhaps that she would consider a motion to reconsider, which technically doesn't really exist under the Tennessee rules of civil procedure, but one might style that as a motion to alter or amend, which we'll talk about in a second because this case has been on remand because of 3 of those motions that were filed. So what ended up happening is that immediately after the order was entered, the following day, before the judge could reduce it to writing, Mr. Hwang filed a motion to recuse the trial court judge. That was the 3rd time he had done that in this case. He also did that multiple times in the Holt case, which we have referenced, and I'm not sure, I don't remember who authored that, and I apologize for that, but that issue was addressed in Holt, and I've addressed it in my brief. But after the motion to recuse was filed, the following day on the 3rd of November of 2023, the judge entered she reduced her oral ruling to writing and entered the order, dismissing the case. And on December 3rd and 4th of 2023, Mr. Hwang started filing documents. He filed a motion to reconsider the court's ruling. He filed 2 different motions to alter or amend, and he filed 4 supplemental responses to interrogatories. Mr. Hwang has never articulated in his briefing at this point as to how that 4 supplemental response would have complied with any order whatsoever. So I would consider that waived. But he also filed on that date a notice of appeal. And Mr. Hwang never attempted to set any of his motions for hearing at the trial court level and proceeded on appeal. He then filed 2 different briefs to which I filed a responsive brief. I had the benefit of inheriting this case whenever it was already on appeal, so I kind of stepped into it whenever it was already full blast. And then Mr. Hwang filed a reply brief. We were set for oral argument in November of last year, and on November 1st of last year, this court entered what I call a non-dispositional remand order that basically said that the parties have within 30 days from that date to get a trial court judge or the trial court judge at the time to rule on those pending motions. I wasn't sure, the pending motions were listed as the 10B motion to recuse, as well as the 3 motions to alter or amend or to reconsider.
Those were the only motions in the record that were outstanding at that time.
That's right.
On appeal.
That's right. And we ultimately did that. It took us a minute. I actually filed a motion for a status conference basically right after I got it because we had holidays around that time. It was hard to get everything scheduled. As Judge Smith knows, there are specific rules on when you set motions for hearing unless you get them specially set, and that's hard to do around the holidays. This court was kind enough to work with us to allow the judge enough time to rule on these motions. Interesting, another rub on this case. Whenever we were trying to get the motions heard, at first Mr. Hwang fought me on it. And ultimately, I guess he realized that it was to his benefit to have the motions heard, so he went down a path to try to get them heard. Something happened on one of what was really going to be a status conference hearing date, and Judge Felicia Corbin Johnson got very upset by something that Mr. Hwang had posted on the internet that I attached as a filing. I'm not sure if that made it into the supplemental record, so I won't get into it. The only thing I saw in the supplemental record was the actual order that was entered.
There's no, to my knowledge, there's nothing in the supplemental record addressing any of that other than the fact that she recused herself and that Judge Higgins took over the case.
Okay. I think in the order, Judge Higgins, in addition to the order itself, also in some attachments, she references the actual order that Judge Corbin Johnson entered. And what that order says is that she recused herself not because of the merit. The original motion to recuse filed right after dismissal had any merit, but because she wasn't going to continue to be intimidated and harassed and have her courtroom staff harassed. I would submit to you without it being on the record, and I know you won't consider it, but that was because of something that happened in court that day and Judge Johnson saw about something that was written about her sheriff deputy online. Regardless, Judge Corbin Johnson recused herself, which set down a path of trying to figure out who would be the judge who would actually hear the substantive pending motions. And that got to Judge Higgins, and all that set out in the order, which addresses the pending motions that was entered on February 24th of 2025. If you will look at the end of that order, it directed that the trial court clerk was to transmit as a supplemental record within 14 days everything that was filed with the trial court post-remand. That didn't happen. And I just got notice that this got filed last week. But again, this is not technically my appeal, so I'm trying to get to the real issues of the case. So going back to the substance of the appeal, unless y'all have any questions about that procedure. I know that was in 25 years of practice, I've never had that happen in a case where those types of pending motions don't get resolved somehow before appeal. But getting back to the substance, this is the Holt matter that I referenced earlier. I have quoted Holt at length in my brief, and I won't talk about it too much other than to say the briefing that appellant did in this case is woefully deficient. The only thing he did different from his briefing in Holt was that he did cite a case, but he did not cite that case for any proposition that would be beneficial to his arguments that the judge aired. He just cited it. And if you read that case, the Illinois Central case, you will see that actually it is detrimental to his case because it outlines why actions such as what he took should be considered to be of the type that would allow a judge not to have abused discretion in dismissing a case for discovery violations. And there's no citation to anything in the record. The record in this case is 1,000 pages long. I went through and took the time to try to explain to you all what's in the record and what it means. Mr. Hwang didn't do a single second of it, not a single citation to the record, the entire brief. For those reasons and because of the Holt case and the other cases that this court has considered, all of his issues should be raised on appeal should be deemed waived, I would submit. Assuming that we get beyond that, Mr. Hwang has raised basically three different issues on appeal. The first is that the judge abused her discretion. Originally, this would have been Judge Corbin Johnson in dismissing his case. The record is replete with examples of Mr. Hwang not having played ball the way he was supposed to under the rules of civil procedure. He's a pro se litigant. He has been since the inception of the case, but he's required and held to the same standards I am. And I can guarantee you that if I had violated 3 court orders in the manner this went down, that I would have been sanctioned beyond what Mr. Hwang was. The dismissal of his case was without prejudice. That was something that Judge Felicia Corbin Johnson always pointed out. And in every order compelling discovery that she entered, she let Mr. Hwang know that if he didn't do what he was supposed to do and properly respond to discovery, that he risked having his case dismissed and potentially sanctions beyond that, fees and costs assessed against him. And he never did it, and the case ultimately got dismissed. This is the type of the conduct that the Tennessee Supreme Court and this court has found many, many times to have been of the type where a judge is fully within his or her discretion to dismiss a case, the nuclear option, dismiss a case, strike pleadings, all those things. This type of sanction is under the court's abilities under Rule 37 and the inherent abilities of the court to control his or her docket and the activities of litigants. So I would just submit there's absolutely nothing in the record that would show the judge did anything other than grant this man a lot of grace in allowing him to try to do what he was supposed to do, which he never did. There was another issue raised as to whether or not the judge should have ruled on or entered the order dismissing the case with a pending Rule 10b motion. 10b motions have to be properly supported. It was not. And there's a litany of case law out there in Tennessee that says that whenever a judge makes an oral ruling, simply reducing it to writing is an administrative function and not a substantive decision that Rule 10b prohibits. And in actuality, the judge is required to make that order, and the judge did that, and there was no requirement that the judge had ruled on that. You will see in the order from Judge Higgins recently that denied the pending motions, she dealt with that in alternative ways, including what I just said. She also just said that it was moot because Judge Felicia Corbin Johnson recused herself. Again, that's an interesting issue because the motion to recuse was filed before whenever the case was dismissed. The judge recused herself based on something that happened unrelated to the motion to recuse a year later. But regardless, the judge's recusal had nothing to do with the ability of Judge Higgins to make her findings, ultimately denying the pending motions. The last issue I have asked for fees and costs to be assessed as one of my statement of issues in this case. I've done that because this appeal is frivolous. The very last point raised by Mr. Hwang in his brief firmly establishes the frivolity of this case. He is trying to claim that an issue of first impression as to why the judge should not have dismissed his case is because of the possibilities of things called judicial crime and white-collar crime. Mr. Hwang has accused everybody under the sun, including judges in this case and lawyers, of crimes. And they're all very vague and unarticulated. And those are not justiciable issues. The Tennessee Supreme Court has defined lack of justiciability as being synonymous with frivolity for purposes of an appeal, and we're asking that costs and fees be assessed to Mr. Hwang for having to defend this appeal. Y'all have any questions of me? That's a big mouthful. I'm out of breath from saying all that.
I think I see none.
Oh, thank you.
Thank you.
Thank you.
We will take this matter under advisement and attempt to get you an opinion as quickly as possible.
Yes, Your Honors.
Thank you.
Thanks.
You may be excused.
Thank you.